We read it once tonight, maybe once tomorrow.
The presiding officer yields to the Senate President with respect to the calling of a caucus tomorrow and what time? Para siya magpakain, hindi ako.
Yeah, well, let me leave it to the presiding officer and Senate President. My proposal is after the oral arguments and after all the senator judges have asked their questions, just so that we have one more night or one weekend to go through it and to, if we're not going to vote on it and we have a consensus, then no problem. And there's a precedent because we did this during the time of the late Senate President Enrile when it came to issues that were of utmost importance that could decide the impeachment trial results one way or the other, but that do have implications in terms of precedents, especially ito pinag-uusapan natin AMLA at saka BIR.
The Senate President is recognized to respond.
I share the same feeling with Senator Judge Alan Cayetano. I started reading both memos, and indeed it's quite lengthy and complicated, and we need to also consult our legal teams. So may I propose, Mr. Presiding Officer, to have a caucus tomorrow at 10 a.m. So that we can thoroughly discuss this.
After.
Mr. Senate President, I mean, I really thank you that twice already during impeachment, without talking, we have the same wavelength. May I propose that if we have a caucus after, just so that we can, for all we know, maganda yung discussion and we're enlightened by the prosecution. And,
so during the break.
And to be honest, I'll probably still be reading this at 10 a.m. No?
If that is the pleasure of the body, we can have a caucus maybe after. No?
During the break.
After the oral arguments, we'll pause for a break and have a caucus.
We can call a longer break, Senator Judge.
Thank you, right. Senate President and Senator.
Is the Honorable Defensor ready after his 5-minute huddle?
Yes, Your Honor. Your Honor, may I request the court to recognize the counsel for the panel of prosecutors, Attorney Lorna Pataho Kapunan, Your Honor.
Attorney Kapunan, counsel for the prosecutors, is recognized. What do you have for us, ma'am?
Magandang gabi po sa inyong lahat. Attorney Lorna Pataho Kapunan, counsel for the prosecutors, under the control and supervision of the House panel of prosecutors. If I may, Your Honors.
Please proceed.
I can see Senator Panfilo Lacson coming in at narinig ko po yung kanyang interview nung sinabi po niya na baka magkaapo na tayo dito at magkaroon na ng national bird, hindi pa tapos ang impeachment trial na to. We have seen this is
Mami said national bird.
Hindi po ba, Senator Lacson? Well, somebody who interviewed you said that you said that.
It must be another senator judge or another person.
Talking about birds. Okay.
Please proceed, ma'am.
I never talked about birds.
Then definitely my information was hearsay. In any event, in the last 4 trial days, we have had several hours of legal calisthenics, direct examination, cross-examination, and today we also had redirect and recross. A total of approximately 8 hours a day and 2 witnesses. Today we are supposed to hear a subpoenaed witness, Attorney Zulaika Lopez, and after her, another witness subpoenaed or called to appear here, Captain Belinda Bello. After hearing the two competent and credible witnesses, not expert witness, but through their credentials showed that they were competent to testify on the matters that they were asked to authenticate. After evaluating through these two witnesses 19 documentary evidence from Agent Kalilong and 45 documentary evidence from our recent witness, Attorney Lotok, and after the very clarificatory and probing questions of our senator judges, after evaluation, and not only during this 5-minute huddle, pero hurdle na rin po yun. It is the wisdom of the public prosecutors as expressed through this representation that we find it totally unnecessary, redundant, and a surplusage to still present Attorney Zulaika Lopez and as well Captain Belinda Bello. Let me just state for the record the reasons why. Had we been able to present Attorney Zulaika Lopez, she would have proven three things, or we would want to have proven three things. First, that she was personally present inside that detention center when the Vice President uttered the video, Exhibit P-4-10, when she uttered the statements that she had contracted, that she had already contracted a killer, and you have heard this already before, and so on, to kill the President, the First Lady, and the Speaker of the House. That would have been the first offer of testimony, that she was personally present inside that detention center when the Vice President uttered those statements. Admitted already, admitted by no less than Attorney Vinluan here, who in his closing remarks or opening remarks mentioned more than 10 times that that press conference occurred, Attorney Zulueta and the Vice President was there, and that in that press conference or a live broadcast, the Vice President did utter the statements we have heard time and again, Exhibit P-4-10. Although Attorney Vinluan says yes, 10 times, I counted just now. I counted that the admission there as to the utterance was made 10 times. Although Attorney Vinluan did say that it is a matter of interpretation. He says that the Vice President did not act as Vice President when she made those utterances. He attempted to give a humane picture to the Vice President that she had reacted as mother, sister, brother? No. And that she was not reacting in her capacity as Vice President. But in that statement that Attorney Vinluan mentioned, there was admission as to the utterances being made more than 10 times. He said, our interpretation is wrong, but again, that is left to the discretion of this court. So that was the first offer. The fact that there were utterances made in a press conference and that Attorney Zulueta was president. No need to present Attorney Lopez for this purpose. Secondly, our second purpose was that Attorney Zulueta Lopez was not only present, but so were other media personnel present there who heard the utterances of the Vice President. And lastly, we would have offered Attorney Zulueta Lopez Zulaika Lopez to confirm the authenticity and the provenance of that video, Exhibit P-4-10. Totally unnecessary because, why? Because the defense themselves used the very same video, said exhibit, in their defense when they showed Attorney Zulueta crying and allegedly complaining about the violation of our human rights. So by their own admission, there is no question about this video. And so it is our contention, and we hereby manifest, that with these admissions on file, and thank you to the senator judges for the clarificatory questions propounded, and I'd specifically like to say thank you to Senator Tito Sen, Vicente Soto, for, in his brief statement, by virtue of clarificatory, brought us back to what this trial is all about. We are not a criminal court, and much time has been spent. Is there grave threats? Is there inciting to sedition? All of this is relevant. But in the context of, is it by doing these grave threats and by inciting to sedition, does it make the Vice President a violator of the Constitution? Does it make her a violator of her solemn oath of office? Is this a high crime? Is this betrayal of public trust? That is what this impeachment is all about. It is not what Attorney Binluan says. If it is grave threats, by all means, we admit. Prison correctional, 6 months to 6 years. And that's a fine of 2,000 pesos. If it is sedition, the same. MTC should be trying these crimes, or the RTC. But that's not what this is all about.
Attorney Kapunan,
Okay.
with your indulgence, kindly
Last sentence.
take up the matter of the presentation of witnesses.
Correct.
Because that is the subject at hand.
So going back to why we are making this manifestation, we have said, and I have said on behalf of the public prosecutors, Your Honors, that we will no longer be presenting Attorney Zulueta and Zulaika Lopez. And, Your Honors, in addition, because the testimony of Captain Belinda Bello is merely corroborative. She would have been presented only to corroborate the fact that there was a transfer order made in the detention center, and that that transfer order had been the subject of the video or press conference of November 23, 2024. And so, Your Honors, we are also no longer going to call as a witness Captain Belinda Bello. With that, Your Honor, I think the reminder of Senator Lacson that the accused, that the respondent is entitled to a speedy trial. Prosecution, the prosecutors would want this to be a reminder to all. We are doing our part we have reduced trial dates by lessening our presentation on this article by 2 witnesses, Your Honor. And therefore, we would also request that the same be also a reminder to the defense counsels or the counsels for the defense. Your Honor, please, in my 48 years of practice as a private lawyer, and I'm grateful for this chance, I have learned 2 things in litigation. The first thing I have learned is, first, learn when to present and not to present a witness, and second, learn when to stop. And I think that should be our takeaway from this manifestation. We have decided from the evidence presented and from everything in consideration that we will not present these 2 witnesses. And on that note, I will also say we know when to stop. And this is where I stop. Thank you.
Thank you, Senator. Thank you, Counsel, for the.
Mr. Presiding Officer.
Madaling malito kasi sa sinabi ni Ma'am Lorna.
Just a quick reply, Mr. Presiding Officer.
Yes, Senate President Gatchalian is recognized.
First of all, let me thank the prosecution for foregoing the 2 other witnesses that is supposed to be presented this week. I was actually talking to our presiding officer earlier on, and I was just computing the number of witnesses. Based on our pre-trial order, the prosecution will present 57 witnesses. The respondent will present 45 witnesses. That's a total of 102 witnesses. At the rate we are going, of 2 days per witness, we will finish in 17 months. That's a year and a half, or a year and 5 months to be exact. So any chance of shortening the proceedings will be highly appreciated. Thank you.
Presiding officer also thanks the Counsel for Private Prosecutors. So therefore, tomorrow, what is calendared for our agenda is the disposition of the 2 requests for subpoena by the Council, by the panel of prosecutors, namely motion for the issuance of a subpoena for bank records and AMLC records, and a motion for the issuance of subpoena ducis tecum as well for the BIR records that we returned via a sealed box. Given that there are no other witnesses to be presented tomorrow, because Director Matibag was scheduled based on an earlier decision of the court on Monday, July 20. I hope we will have sufficient time to discuss these 2 subpoenas tomorrow in our trial. To remind, both parties shall be given 10 minutes to discuss the 2 motions, given that, and this will be discussed jointly already, given that you filed your respective memoranda jointly as well, discussing the 2 issues. You will be given 3 minutes by way of rebuttal and 3 minutes by way of sur-rebuttal, should it be necessary. Thereafter, the senator judges will proceed to discuss the matter in caucus and thereafter in plenary. Yes, Senator Judge Alan Cayetano.
May I just ask, through the presiding officer, is 10 minutes enough?
Your Honor, we will be raising our request to make it at least 15 minutes per part.
Because, sorry, I'll just use myself as an example. No? I want to draw the line between a fishing expedition and this is definite, di ba? And of course, if you can answer it in your presentation, better. I don't have to ask questions anymore. And I can tell you very honestly, I'm really interested in this issue. So may I ask my dear colleagues, can we, since we don't have any other witness tomorrow, I think it will go faster if we give them more time and ourselves less time. Maybe 15 or 20 minutes each, and then
15?
Maybe, Mr. President, Mr. Presiding Officer, you said 3 minutes rebut. I mean, can we give them more time to rebut each other? I'd rather they be rebutting each other than rebutting us. But I think this will really be an issue that will educate all of us, and it'll really be good for the impeachment court and the Filipino people. So may I ask
The Honorable Defensor, 15 minutes.
Yes, Your Honor. 15 minutes per argument and 10 minutes per party on rebuttal, Your Honor.
So 15 and 10.
Yes, Your Honor. If
How
the
about
defense will
counsel
agree.
correspondent?
We will just submit, Your Honor, to the discretion of this honorable court.
15 minutes for the oral arguments in chief, and then 10 minutes by way of rebuttal and rebuttal. And a reminder to the senator judges. Each senator judge can speak for a maximum only of 10 minutes and for a total of 1 hour for each side. Meaning to say, the side to grant the motion and the side not to grant the motion. So kindly discuss also among yourselves to make use of the time with respect to taking up and tackling your position if you are for or against the motion, so that the period of time will be maximized. Senator Judge Soto is recognized. Yes, sir.
Did I hear you right, Mr. Presiding Officer, that you're going to allow us each 10 minutes?
But in no
That's,
case to
I'm
exceed
sure
a maximum of 1 hour, Senator Judge Soto.
For everybody, but I'm sure not everybody will avail of 10 minutes. But if we do, that's 240 minutes.
Again, to reiterate, Senator Judge Soto, a total of 1 hour for each side. But a maximum of 10 minutes per Senator Judge each time they stand to speak. So it will be a maximum of 2 hours for this interlocutory issue of the motion for subpoena. Yes, Senator Judge Allen.
With the permission of former Senate President Soto, let me clarify. 2 minutes to ask clarificatory question. You're referring to the 10 minutes, 1 hour, when there's a motion already.
Yes.
So that assumes, dear Senator Judges, that we don't have a consensus after the caucus, and then we're going to debate it. Yeah, yes, that's why it won't last that long. I mean, assuming we all have questions na 2 minutes, so it's 48 minutes,
if
give
I
or
may
take.
correct, Senator
Then
Judge.
the 10 minutes and 1 hour is if we have a debate whether or not to grant.
If I may
it,
correct,
diba?
Senator Judge Allen, the 2 minutes, if at all, applies to evidentiary issues and questions that we can throw to either party or the witness. But in this case, after an elongated oral presentation by both sides, both in chief and on rebuttal, we should just listen and then go into caucus and decide if we can agree. If not,
Yes.
then we go out and
And-
debate for a maximum of 2 hours, 1 hour on
Agree.
each side.
Each side, but those are different subpoenas, different for the BIR and the
As I said,
AMLA.
Senator Judge Allen.
To your point, former Senate President Soto, that's times 2 pa.
No. Senator Judge Allen, as I said earlier, since the memoranda was submitted by the parties jointly on these twin motions, we will be deciding on it jointly as well.
But would it be possible that we all agree, let's say, on the AMLA but not agree on the BIR, or vice versa, or we both agree on both? Because there are different laws governing AMLA and BIR. Anyway, that's why we'll have a caucus.
Yes, so may I suggest, Mr. Presiding Officer, and of course my esteemed colleague, may I suggest that we decide on how long each senator would be given after we caucus?
Yes.
Instead of setting it now, let's set the prosecution and the defense and and then we'll go into caucus, and then we decide in caucus how long will we be giving each member, if we so decide to still debate here, instead of getting into a consensus in the caucus.
Senator Judge Soto, I completely agree. However, the presiding officer was merely citing what's written in our rules right now. We can, of course, change it by agreeing amongst ourselves to lower it or increase it. Hopefully not in the direction of increasing it.
Hopefully after the caucus, we will have a win-cheese solution.
Thank you, Senator Judge Allen. Any other points? Senator Judge Pangilinan is recognized.
Very, very quickly, Mr. President, this is pertains to an earlier manifestation. I beg the indulgence of our colleagues because it took me some time to retrieve the file. This is reference to my earlier interpellation with the witness on the matter of the case of People versus Mas. Earlier, it was manifested that this was an inciting to sedition case, which was dismissed by the Regional Trial Court. Just for the record, it was dismissed by the Regional Trial Court, not on the merits. It was dismissed by the Olongapo Court because on June 24, by Judge Richard Paradesa of the Olongapo Regional Trial Court, because it was an unlawful arrest. In other words, Mr. Mas was arrested unlawfully, and therefore the Regional Trial Court had no jurisdiction, and so the motion to quash was dismissed, was granted rather, and the case was dismissed. In other words, it was not dismissed on the merits. For the record, Mr. President.
Yes, Honorable Defensor, just to remind you that tomorrow, kindly give us a list of your witnesses for the following week for the information of the court as well as for the other party.
We will, if necessary, Your Honors.
And will you be needing a subpoena for Director Matibag for Monday?
we won't need a subpoena anymore for Director Matibag for Monday's testimony, Your Honor.
Okay, then no need to issue a subpoena. Any other points the counsel for respondent would like to raise?
No
Your
more.
Honor, just to, before we end, can we
Yes,
request
Honorable
the
Defensor.
clerk of court to reseal the evidence, especially...
Yes, after we adjourn, may I request the counsel, assisting counsels for the parties to kindly meet and reseal the USBs that were opened by the witness earlier amongst yourselves.
Your Honors, we have no other matters for consideration this evening, Your Honor.
There being no other business to be taken up by the court, trial is hereby adjourned until 2 p.m. of Wednesday, July 15, 2026. Thank you very much to everyone.
At yan po ang day 5 ng paglilitis ng impeachment trial laban kay Vice President Sara Duterte. Sa pagtatapos nga ng day 5 ng impeachment trial ay sinabi ni Counsel for Prosecutors Attorney Lorna Capunan na hindi na nila hihinging humarap pa. Sa impeachment court, sina Attorney Zulaika Lopez at Captain Belinda Bello, ang Executive Director ng House Legislative Security Bureau. Ayon kay Attorney Capunan, Jasmine Jing ay hindi na kailangan ng kanilang mga testimonya dahil sapat na yung mga testimonya ng naunang dalawang testigo mula sa National Bureau of Investigation, sina Senior Agent John Mark Calilong at Attorney Jeremy Lotok, si NBI BARM Regional Director. Ang sabi rin ni Capunan ay sapat na yung kanilang nakuhang ebidensya at wala nang maidaragdag pa mula sa mga testimonya ni na Attorney Lopez at Captain Bello.
Noong una kasi pinag-iisipan ng madami, kasama na din kami, kung ano ang silbi ng testimonya, magiging silbi ng testimony ni Attorney Zulaika Lopez at ni Captain Belinda Bello. Ayon kay Attorney Lorna Capunan, sabi niya na ang purpose lang daw nila to testify na nandun sila. At narinig nilang sabihin ni Vice President Sara Duterte yung mga sinabi niya na napanood natin lahat sa internet at dito sa impeachment trial nung ganap siya ng press conference noong November 23, 2024.
So, ang isa pang dahilan din kung bakit hindi na rin ipipresenta yung dalawang witness na inaasahan sana natin magpapakita ay sabi ni Atty. Capunan, ito rin kasi yung mga videos na inamin din ng depensa. So, kung nagkaroon na ng pag-aamin, there's really no need for them to present. Kasi, in other words, parang all of them agreed na ito ang sinabi ng Vice President sa video, na nandun si Attorney Zulaika kasama si Vice President.
Kumbaga, sinasabi
what for, di ba?
Oo, at kumbaga sinasabi rin ng prosekusyon, no? Kumbaga sinasabi nila na ginisa rin ng depensa ang kanilang mga sarili sa sarili nilang mantika. Ay, hindi ba? Dahil, kanina nga, binanggit din ni Attorney Lorna Capunan, ang depensa mismo sa pamamagitan ni Defense Counsel Attorney Mark Binluan ang nagkumpirma ng mga detalyeng gusto nilang kumpirmahin mula kay na Attorney Lopez at Captain Belinda Bello, at bakit pa nga naman magpipresenta ng karagdagang mga testigo ang prosekusyon, no, kung maaari pa itong masilip, no, at ma-cross, no, at masuri ng depensa kung in the first place matibay na yung kanilang na-establish, no, na mga testimonya mula sa mga naunang dalawang testigo, at naging mahaba at masusi nga, hindi ba, yung direct examination, cross-redirect at recross examination kay Attorney Lotok. At sinabi nga rin ni Attorney Capunan na kailangan alam din natin kung kailan tayo dapat tumigil.
Yes.
Oo. At sinabi din ni Attorney Capunan na hindi naman ito tulad ng trial court. Hindi kailangan kasing busisi ng mga nagaganap sa trial court, no? Na pati yung mga numbers dun sa mga dokumento ay matagal na pinag-usapan. So sabi niya, in the interest of time, dahil gusto nilang mabilis din matapos itong impeachment trial, i-forgo na nila yung testimony ng dalawang witness nila. So ang mangyayari bukas ay meron oral arguments ang
Impeachment court,
ang senators.
Yeah.
Magpe-present muna ang defense at ang prosecution, tapos may oral arguments ang senators, 1 hour each sa dalawang kampo, either for or against. Yung defense at prosecution naman, binibigyan ng 15 minutes each, no, for their presentation and 10 minutes for rebuttal.